Hello, everybody. I hope you're having a great day. My name is Isaac Sturgill. I'm a housing attorney with Legal Aid of North Carolina, and I'm here today to teach you how to appeal an eviction judgment. So it's important to know that in North Carolina that tenants have the right to appeal an eviction judgment if they lose their case. So eviction cases, or summary ejectment cases, as we call them, the legal term, they move pretty fast to start out with. So the first trial usually happens within a week or so of when the landlord files the case. That can be pretty stressful for people, especially if they're not familiar with the process. The first trial almost always happens in small claims court. And sometimes tenants aren't even able to make it to the first trial. Sometimes it happens so quickly that they're not able to get time off of work, or they may make it to the trial but feel unprepared and not be happy with the result. But fortunately, there is a process to appeal the judgment from small claims court and ask for a new trial in district court. And that's what we're going to talk about today. So first of all, who is allowed to appeal? So whoever loses the small claims trial can appeal. This is true even if the person who wants to file the appeal does not show up for court. So let's say you're a tenant and you miss your eviction court date and you're asking yourself, well, what do I do now? What rights do I have? One right that tenant does have is to file an appeal. It's important to know how long someone has to file an appeal. If the judgment was announced in open court, so if the judge announced the judgment in open court and told everybody what happened and what the decision was, then the person who wants to appeal has 10 days from when the judgment was entered to appeal it. Sometimes the magistrate or the judge in small claims court will not announce the decision on the day of trial. And so sometimes they will reserve judgment, they'll think about it, and then they'll send the judgment in the mail. In that case, the tenant has 13 days from the day the judgment was entered to appeal. Why the extra 3 days? Because the law figures that that's how long it will take to make it through the mail from the date that it's signed. Some other questions to think about. Can a tenant stay in the home while waiting on the appeal? Yes, they can, but only if the tenant posts a bond with the court. That's what we call a rent bond. And we're going to talk about that more in just a couple minutes. Does it cost any money to file an appeal? Usually it does. It usually costs $150 to file an appeal in North Carolina. However, some people may be able to get that filing fee waived, and we're going to talk about how to do that too. What happens if a tenant does not appeal? So if the tenant does not appeal in time, or if they appeal and they don't post a rent bond, the landlord may get the court to issue the paperwork to change the locks after the window to file the appeal closes. And let me say this, that is a strict deadline. So if you want to file an appeal, it's usually 10 days when the judgment is announced in open court. That's a strict deadline. So it's something to be careful with. If you want to file an appeal, it's good not to wait till the last minute. Do it early in case something comes up so that you don't miss that window. And finally, if a tenant files an appeal, how long does it take for the appeal trial to happen? That kind of depends on what county the tenant is in, because some counties have more eviction cases than others, but it's usually something like 5 to 8 weeks. So you can see, although you usually don't get a lot of time to prepare for the first trial, if you lose the first trial and appeal, you do get a lot more time to prepare for the second trial or the appeal trial. So now let's talk about what paperwork does someone need to file to appeal the judgment. And there are 3 forms that can be used. The first one is the notice of appeal. That's the paperwork that creates the appeal and puts the other side on notice that the appeal is being filed. The second is called a petition to proceed as indigent. This is essentially a fee waiver form. So for people who qualify as indigent, it gets rid of the filing fee, and it also reduces the amount of bond that the tenant has to pay to stay in the home. And we'll go into some more detail about that later. And then finally, there's a form called the bond to stay execution. This is the form that sets the bond the tenant must pay in order to stay in the home while waiting on the appeal. So let's go ahead and look at the forms. And before we jump into the different forms, I want to show everyone where you can find them. So a lot of the times, if you go in person to the courthouse, if you go to the clerk, It's usually the clerk, the judgment's clerk at the courthouse. A lot of times they'll have these forms available at the courthouse itself, but you can also find them on this website. It's nccourts.gov. And if you scroll down to the bottom, you'll see a link down here that says forms. And so there's a button here that says find a form. You can click that. There's a bunch listed down here and you can scroll through them, but I think that the easiest way to do it is to just do a keyword search. So for example, if you type in, notice of appeal, which is one of the forms we talked about, then it'll automatically bring that form up right here and you can click on it and it'll take you to the form that you're looking for. Now, there is a function on here that's pretty new. It's the eCourts guide and file system, and that's like a computer program that's free to use. And some of the forms we're going to talk about today are on the guide and file system. So you can check that out too. You can click on it and click on notice for appeal, for example, which is the first form we're going to look at. And instead of just bringing up a blank form, it'll ask you a bunch of questions to fill out, and then it'll fill out the form for you. However, not everybody has access to a computer or to this software, although it is free on the website. And also some people find it difficult to use. So this video is for people that either are not able to access that or maybe you try it and you don't like it and you'd like to just fill it out by hand. So going to the first form, we're going to start with the notice of appeal to district court. And this is what it looks like. And we're going to kind of go through each line one at a time to show you what you need to do. So the first thing up here you want to do is fill out which county it is. Now, if you pull this form up online like this, it's a PDF and you can type it in. You can also just print it and handwrite it. The court doesn't care if you handwrite it as long as it's legible, as long as they can read it, that they're not going to care whether it's typed or it's handwritten. So I'm going to go ahead and put in here Mecklenburg because that's the county I live in. The file number. So your paperwork that you received when you were served with your eviction papers should have the file number on it. You should have received at least a complaint and a summons, and this file number should be up at the top. Usually it's the year. So right now it's 2021-CVM, and then it will have some numbers afterwards, and we'll just put zeros there for right now. After the file number is entered, you're going to want to go to the name of the plaintiff. Now, the plaintiff in an eviction case is the landlord. And people sometimes get this mixed up. And if you're not used to being in court, it may be confusing about who's the plaintiff and who's the defendant. But the plaintiff is going to be the landlord. So you're going to put their name in there. We're just going to make up a name. So I'm going to say Larry Landlord. And then the defendant, if you're the tenant filling out this form, you are the defendant. You are the one who has the lawsuit filed against you. And so I'm just going to make up another name, Terry Tenant. Let's say that. Sometimes there's more than one defendant. So if there's a second defendant, you can put their name in there. And so that's the first part. And this is, common to all three forms. This first top part is just called the case caption. It just explains what county it's in, what the filing number is, and the names of the parties. So scrolling down, the next part, you have to identify whether you're the plaintiff or the defendant. We just said if you're the tenant, you're going to be the defendant. So we're going to check the box that says defendant. And this just says, as the defendant in this case, I'm giving my notice of appeal. And I'm giving it within 10 days of the date of judgment, which is the appeal deadline. The next box, you have to certify that you're going to serve a copy of this notice of appeal on the other party, which essentially just means you're going to send a copy of this to your landlord. And that's a requirement. So you're going to check the box saying, yes, I'm going to do that. The third part, you have a choice when you do an appeal. You can ask for a judge trial, a bench trial, which means a trial without a jury where the judge makes the decision. Or you can ask for a jury trial where you have a jury of 12 of your peers and the jury makes the final decision on the case. You have the right to ask for either one. Typically, jury trials are more complicated. So a lot of places, if you do a jury trial, you're going to have to do a pretrial memo. You're going to have to go through something called a voir dire or a jury selection process. And it can be harder and more intimidating for people who do not have an attorney to go through that process. So if you're not comfortable with those extra steps, a judge trial may be easier to navigate just because there's less steps that you have to go through. So for right now, we'll say a judge trial. Entry of judgment. This is going to be the date that the judgment was signed and file stamped with the court. And let me say this, typically in eviction trials, you don't automatically get a copy of the judgment the day of trial. So you may go to the trial and the judge will announce the judgment in court, but they're not necessarily going to give you a copy of it when you're there. So sometimes you may have to wait a day or two and then go back and ask the clerk for a copy to, so you can get a copy of the judgment. Let's just say in this case that the judgment was entered on, let's say July 1st. So we'll put that in there. And then the date of the appeal. And so this is the date that you're actually going to file the appeal paperwork. So let's say we did that on the 6th, which is fine because that's less than 10 days from when the judgment was entered. The name of the appealing party, that's going to be just your name. So our fake name we're using is Terry Tennant. And then right here, and I can't do this on this form, but right here, you're going to have to sign it. So where it says signature of appealing party, if you're the person doing the appeal, that's where you would put your signature there. This part talks about the court cost. If you are filing as an indigent, which we're going to talk about in a minute, you would just put NA there because you're going to, or not applicable because you're going to get those court costs waived. If you don't qualify as indigent or you don't file the petition for indigency, then you would put the date that you pay the appeal cost to the court. And then on the amount of the court cost paid for the appeal is $150. Let's assume for this example that you are going to fill out the fee waiver form or the indigency form. And so in that case, you would just put not applicable because you're going to get those costs waived, and we'll just put 0 there. Name of appealing party 2 and the signature. If there's another party that's appealing with you, like let's say there's 2 defendants and both of you are doing it, that's the place for them to put their name and to sign. Okay, scrolling down to the next part that you fill out, and you want to read the rest of this. This just talks about court cost, certain other requirements. But the next part you fill out is you go down to what we call the certificate of service. So out of the 3 forms that we're going to fill out today, this is the only one that you have to serve on the other side, or you have to serve on your landlord. And this is how you certify that you did that. And there's different ways that you can do it. I think the easiest way to do it is just by regular mail. But if you wanted to, personally deliver or hand deliver a copy, you could do that. Or leave a copy at your landlord's attorney's office with an employee there, you could do that. But usually the easiest way is just to mail a copy. And it doesn't have to be certified mail or registered mail or anything like that. It can just be regular old mail. So we're going to click on that we did it by regular mail. And then who did we mail it to? If you're mailing it directly to your landlord, you would click the plaintiff. If your landlord has an attorney and you're mailing it to your landlord's attorney, you would click plaintiff's attorney. Let's assume in this case, landlord does not have an attorney, so we're just going to mail it to plaintiff, which is your landlord. Then finally, at the very bottom, this is just more information about how it was served. So you're going to put the date it was mailed or delivered. This should be, the same day that you filed your appeal. So up here, for example, we filed the appeal on July 6th. So that's the same day that we're going to mail it. You should mail it the same day that you file it. Name and address to whom it was mailed or delivered. We're mailing it to our landlord, Larry Landlord. Let's just make up an address, whatever. Right here, name of person serving the notice of appeal. If you're the one that's mailing it to the landlord, or if you're the one that's serving it, you're going to put your name there. And then title, in this case, if you're the defendant and you're the one serving it, you just put defendant. That's that's who you are in this case. And then you're going to have to put your name and address on this part. This says name and mailing address of appealing party 1. So we'll just make up an address there. Okay, so after that, you're going to sign it again. So this is the second place that you're going to have to sign on this form. And when you sign this, you're just certifying that this is true, that you did serve a copy on your landlord, that you mailed it or hand delivered it or whatever box you checked, that this is your landlord's address, that this is your name and your address, all of that stuff is accurate. And after that, you are done. If there's a second appealing party, so if you have a co-defendant or another person that's appealing with you, you put their information there. But if it's just one person, that's the end of this form. So that's the notice of appeal. And that's the first form that you're going to file. And again, this is the form that creates the appeal and puts the other side on notice. Moving on, let's look at the indigency petition. Now, this first part, I'm going to go ahead and do quickly without explaining it too much because it's the same as last time, right? This is, remember, the case caption. So we're just putting the county, we're putting the landlord's name, we're putting our name as the defendant. Remember, if you're the tenant, you're the defendant. We're putting the file number up here. And also, and I may have forgotten to do this, I'm gonna have to go back and correct this. When you file this, you have to choose district or superior court. For these eviction trials, they're always gonna be in district court. So you should check the box that says district court. I may have forgotten to do that on the, nope, on the last one, it already has that on there, okay. So the notice of appeal already says district court, but on this indigency petition or the petition to proceed as an indigent, you're gonna have to click that box that says district court. All right, so this is the form that gets the filing fee waived and reduces the bond. And the first part is just asking why do you need to do this fee waiver, right? Now, if you were gonna file counterclaims, you might click petition to assert claims. If you're going to file motions in the case, if you wanted to do that, you could do petition to file motions. What we're really looking at is the petition to appeal, right? So we want to file our appeal without having to pay the filing fee. So we're definitely going to click that one. But really, if you think there's any chance that you may file counterclaims or that you may need to file a motion in the case, you might as well click these other two as well. It's not going to hurt anything if you do that. If you end up not filing motions or not filing counterclaims, that's fine. But it might be worth just checking all three of those just in case you decide you need to do a claim or a motion later down the line. The next part asks about why you need to do a petition to proceed as indigent. And indigent just means that you don't have the funds to litigate the case or pay for the filing fee. And there's a couple of different ways that you can show this to the court. If you get any of these benefits, so if you get food stamps, if you get TAMF, or if you get SSI, you can just click that. So let's say I receive food stamps, I could just check that box, and I could check the box that says I received food stamps, and that would be enough. Or if I just got SSI, I could do that too. Now, I will tell you that some clerks will want proof of that. So some clerks in some counties, if you're going to file this petition for indigency, and you check food stamps, they may want to see a reward letter from DSS showing that you have food stamps, or they may want to see your card, your food stamp card, to prove that. The same thing for SSI. They may want to see an award letter showing your Social Security benefits. Some courts are stricter than others, so some counties will ask for that type of stuff. Some counties will not. It just depends on where you're at. If you have any question about that, it may be worth calling ahead to your court and asking to speak with the clerk and just ask them that if they're going to require any proof when you show up. But let's assume that I get food stamps, so I'm just going to check that box. Now, if you don't receive any of those benefits, there's a couple other ways that you can get this done. One, if you have an attorney representing you who is from legal aid or some other nonprofit legal services organization, you can check that box, but your legal aid attorney is going to have to sign down here at the bottom saying that, yes, this person is one of my clients and I work for a nonprofit law firm. The last way that you can do it is just a catch-all. So it just says, I don't get any of these benefits. I'm not represented by a legal services attorney, but despite all that, I'm still financially unable to pay the cost of filing the appeal. If you check that box, different counties are going to have, and different courts are going to have different requirements. Some may make you actually fill out an affidavit, like a budget form showing your income and showing your expenses, so they can determine whether or not you are actually unable to not to afford the cost of the appeal. Some counties may have other questions that they ask you. It just depends where you're at. So that's another thing. If that box is the only box you can check, you may want to call ahead to the clerk's office in the county that you're in and ask them, you know, what proof that are they going to ask for if you check that box. This form does need to be notarized because it's an affidavit. It's a sworn statement. And so you have to sign this under oath. You can get a notary to do it. You know, most banks have a notary. If you want to do it that way, it's like $5 to get a notary to sign it. Some courthouses will have a notary on staff that can do it for you for free. But again, that's something that depends on which county you're in. So that's another question. If you don't know, you may want to call ahead to the clerk's office and ask them, you know, do you have a free notary on site that I can use? If they say no, you may have to, you know, find a notary on your own to do that. The notary is going to fill out this left part right here. So you don't mess with any of the left part, but on the right part, you're going to put, again, you know, the date that you're signing it. You're going to sign it right here where it says signature of petitioner. And then again, you're going to put your name and your address on this part. I forgot what our fake address is, so I'll make up another one here. Okay, when you're done with that, you're pretty much done. So this part, the certificate of legal services pro bono part, you don't sign that. That's the part your legal aid attorney would sign if you have a legal aid attorney. And then the bottom part, you definitely don't mess with because that's the part that the clerk of court is supposed to sign. So after reviewing this petition, either a clerk or a judge can review it, but after one of them reviews it, they will look at it. If they authorize it, they'll check this box that says that the petition is authorized, which means that your fee waiver has been granted and you don't have to pay the filing fee. If they deny it, then it's denied and you're going to have to pay, unfortunately, the filing fee out of pocket if you want to move forward with it. And then this last page does not apply to us, so you can ignore this last section right here. All right, we're making progress. We're almost done. So the very last form is the bond form. And this is the form that creates the stay or keeps the landlord from being able to change the locks while you're waiting on your appeal. This is the one that lets the tenant stay in their home while the appeal is pending. I'm going to go ahead and put our case number back in here again. I'm going to put the name of the parties. Now this one's a little different. It says the caption asks for the name and the address of the parties. So we're going to put both up here. It's a little different in that way. So I'm going to put our address up here. Now you don't, and I'm just, again, don't pay attention to the addresses. I'm just making those up off the top of my head. You don't have to click district court because it already has district court in there. And so let's move down to look at the rest of this form. So the first part, just ask again for the date of the judgment. I believe we said our judgment was entered on the 1st. So we're going to put the 1st on there. The amount of rent. So this will be the amount of rent that you pay, and it should match what is on the complaint that the landlord files. So let's say it's $1,000 a month. You can check a month. If you pay weekly rent, you put the amount per week right there. Now, this is the day of the month or the week that rent is due. So rent is usually due on the 1st of the month. So if it's a monthly lease, not always, but most of the time it's due on the 1st. If it's a weekly lease, it would be whatever day of the week it's due. Maybe it's Tuesday, maybe it's Wednesday, whatever. But let's say in this case, it's a monthly lease. You pay once a month on the 1st of the month. So we'll put that. And this here is essentially a promise or an understanding saying that I understand that I'm agreeing to pay this amount, the amount above, every month while this case is pending to the court within 5 business days after it's due. And if I don't do that, then the landlord can file the paperwork to go ahead and get the sheriff to come out to change the locks on the property. And so what that means is that once you file this form, and this is true for everyone, while your appeal is pending, each month that comes around, you have to pay your rent, whatever portion of rent you pay. If you're subsidized, that may be just your portion. So if you're Section 8 or something like that, and your portion's only $400 a month, that's what you'd pay. If you're not subsidized, if you're not Section 8, if it's just private housing, you would just pay whatever your regular rent is. But whatever rent that you pay each month, you're going to pay that into the court, and it's due within 5 business days of whenever the rent's due. So if the rent's due on the 1st of the month, you have to pay it within 5 business days of the 1st. So the date here is just whatever date that you're going to sign it. And then there's a place here to sign. So signature of defendant, that means the signature of the tenant who's filling out this form, which would be you if you're the one appealing the case. This actually talks about the amount of the bond that you're going to have to pay in order to stay in the home while you're waiting on the appeal. And there's actually a couple different requirements. So we talked about one requirement is you have to pay the rent as it comes due each month within 5 business days of when it's due, right? That's true for everyone. These other 2 bond requirements, you may or may not have to pay depending on the case and your situation. So the first is the undisputed rent in arrears. That means the back rent, right? Normally, whatever back rent is undisputed, like you don't dispute that you are behind $1,000, for example. Normally, whatever that back rent is, the tenant also has to pay that as a bond payment, in addition to the first bond payment we talked about. However, if you have filed a petition for indigency, that fee waiver form we talked about, and if that petition's been granted by the court because you have food stamps or you're represented by legal aid or whatever the reason, then that bond requirement is actually waived. So if you qualify as an indigent, you don't have to pay the back rent as a bond in order to appeal. So in this case, because I received food stamps, and I'm going to say that I did the fee waiver, the indigency petition, it was granted by the court. We're going to say that this bond requirement is waived. I don't have to pay it, so I'm just going to put it not applicable there. Now, the last one is the amount of prorated rent. So this is the final bond requirement that applies in some cases, but it only applies to cases for non-payment of rent. So if the eviction is for non-payment of rent, in addition to whatever other bond requirements, you're going to have to pay a prorated amount of bond that's going to go from the date of the trial to the end of the month. So let's say your trial was on the 15th of July. You're going to have to pay a prorated amount, whatever your rent is, from July 15th through July 31st. So, we're going to just make up a number at this point. Some people don't like to fill this out. They like to, because they're afraid they'll get the math wrong. So they'll leave it blank and they'll ask the clerk to help them fill it out. That's fine too. But let's just say in this situation that the amount of prorated rent, I'm just making up a number, from the day of trial to the end of the month is, I don't know, $900. But again, this is only for non-payment cases. So if you're being evicted for something other than non-payment, then you should not have to pay a prorated amount of rent. And I will tell you, sometimes clerks get that wrong. So if you're appealing a case and it's not a non-payment case and the clerk tries to pay you or tries to make you pay a prorated bond, you may have to ask to speak to a supervisor or point out to them the fact that this is only for non-payment cases. In this case, we're going to pretend it is a non-payment case. So I'm going to put the prorated amount in there. And again, if you don't want to do the math and if you want to get the clerk to help you figure out that number, it's fine to leave it blank and to ask the clerk to help you with that. And then finally, at the end, this just asks you to add up the undisputed or written arrears, which is nothing for us because we got that waived. The prorated amount, that's $900. This is date of deposit is going to be the date that you deposit the money. We're going to say, or that you pay the money. We're going to say that's the 6th in this situation. And then right here, again, you're going to sign the form. And that's the bond form. This form is really important, again, because this is the form. You can do the appeal and you can even do the indigency petition, but if you don't fill out the bond form and if you don't pay the bond, then you're not going to be able to stay in the home while you're waiting on your appeal. Even though you filed an appeal, if you don't do this form and if you don't pay the bond to the court and keep the bond current as time goes on, the landlord can file the paperwork to have you locked out even while you're waiting on your appeal to be heard. The very bottom part of this form, the order section, that is for the judge or the clerk to fill out, so we don't mess with that. So after doing that last part, we're done. So it's not as complicated as it looks. You know, there's only 3 forms. We just went through all of them, and you know, you can get them filled out with the bond form again, with the math and calculating the rent. If you want to wait until you get to the clerk to get them to help you do that, then that's fine. But those are the 3 forms that you can use to file your appeal. So just some other general tips. When you go to file an appeal, you're going to need extra copies. And so you're going to need at least 2 copies of the bond form and the petition to proceed as indigent. Those are the second 2 forms we talked about. The reason why you're going to want 1 form to keep for yourself and 1 form the court's going to keep of each of those. For the notice of appeal, you're going to need 3 copies, because remember, that's the one that you also have to serve on your landlord. So for the notice of appeal, 3 copies, 1 for you, 1 that the court keeps, and 1 you're going to mail to your landlord or deliver it to them however you said you did on your form. And finally, the tenant may want to call ahead to the clerk to see what kind of payment the court will accept for the filing fee and for the bond payments. So some courts do not accept personal checks. In fact, most of them don't. Sometimes you can pay with a credit card, but they'll charge you a fee to do that. The safest bet is cash or money order. But if you have any questions about that, it's fine to call ahead and just make sure. And that's it. I hope this was helpful for anyone who is needing to file an appeal or planning on filing an appeal. For tenants who would like free legal representation or advice, legal aid is free for those who qualify for our services. And you can reach us on our hotline. It's toll free. It's 1-866-219-LANC or 5262. And our website, legalaidnc.org. Thank you so much. I hope you have a great day. And I hope this information was useful. Bye-bye.